started the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website, and we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome everybody. Thank you for joining us for today's online talk on duties of executors and trustees. What do you need to know? My name is Karmen. I'm an associate with Vivien and Associates, and I will be your moderator for today's session. Before we start today's session, allow me to introduce the firm and what we do. Vivien and Associates is a mid-sized law firm that was founded in 1985 by Datuk Vivien. Our able team today comprises of 23 lawyers and a support team of 19. Datuk Ma is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small, medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution team. Today is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 Movement Control Order, or the MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. This is the 35th talk in our MWKA online talk series. Please feel free to visit our website at mahuinkwai.com for more information, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute a legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Now allow me to introduce both of our speakers for today. Our first speaker is Ms. Vivien Fung, an associate in our Dispute Resolution and Individuals and Families Department. She holds a Bachelor of Laws from Cardiff University and was called to the Bar of England and Wales in 2016. Vivien was then admitted to the High Court of Malaya in 2017. Vivien's practice areas include general litigation, particularly in debt recovery, criminal, construction, land acquisition, probate and administration of estates, contractual disputes, and tenancy disputes. Our second speaker is Ms. Prisilla Chong, an associate in our Dispute Resolution Department. She holds a Bachelor of Laws from Cardiff University and was admitted to the Malaysian Bar in 2017. Prisilla's practice areas include general litigation, corporate and commercial litigation, arbitration, real estate and land dispute litigation, probate and administration of estate. Our speakers hope to complete today's talk by 3:45 p.m. and thereafter proceed with the Q&A session. So if you have any questions, please don't forget to post them up on Slido and our speakers will address them later. You should have received a link to Slido during registration, but I will leave this slide up for a few seconds so that you can scan the QR code before we move on. Alternatively, you can also go to Slido's webpage and key in the code 10850. I repeat, 10850. So we'll move on to the top points of today. Despite being the executors and trustees of an estate, many of us are unsure exactly how to administer the estate as executors or trustees. For today's session, Vivien will start the talk by giving us an overview of the administration of estates. She will also move on to discuss the duties of executors and trustees. Our second speaker, Prisilla, will then take over to discuss the common breaches by executors and trustees. She will then end her session by addressing how beneficiaries can protect their interests. With that said, I will now invite Vivien to share her insights. Over to you, Vivien.
Thank you, Karmen. Good afternoon, everyone. Thank you for tuning in our online talk today on duties of executors and trustees in the context of estate administration. I'll be giving you an overview of the administration of estates and the duties of executors and trustees. And my colleague Prisilla will be enlightening you on the common breaches by executors and trustees and how beneficiaries can protect their interests under the estate. There are a few things you need to know about the administration of estates, and that includes the properties of a will, the difference between a grant of a probate and a grant of a letter of administration, and the process of applying to the High Court for the grant. In a testator's will, it will usually set out who the testator wishes to appoint as the executor and trustee of the estate, guardian, if they are minors, and will set out the manner of distribution and the beneficiary's entitlements to his or her assets, movable and both immovable. A will is automatically revoked upon marriage unless expressly stated in a will that it is made in contemplation of a marriage. So for those who are making a will or who has made a will and is not married and intends to get married, this is something to take note of. Okay, now we will look at the grant of probate. If a person passes away and leaves behind a valid will, we will refer to that situation as testacy. And if a person dies without leaving a will, we will refer to that situation as intestacy. So the will takes effect upon the death of the deceased, which will now be called a testator, and a will is a testamentary document. A valid will usually appoint an executor to administer the estate, and the executor will apply to the court for the grant of probate before he or she affirms on oath to administer the estate. So what makes a valid will? It's important to take note because any persons interested, such as beneficiaries or otherwise, can challenge the validity of the will and apply to the court to declare it invalid, null, and void. And if that situation arises and a will is declared invalid, then technically speaking, there's no will, and we will have to go through the administration through the grant of letter of administration. The will have no effect at all. Situations where challenges are made as to the testamentary capacity of the testator when the will was made, whether he or she was ill at that time, of unsound mind, memory loss, and whether he or she actually fully understands the contents and effects of the clauses stated in the will when the will was read to him or her before she executes it. So for those who are interested, persons interested to the estate and wish to challenge the will, they will usually attack on the testamentary capacity of the person who passed away when the will was made. Other situations include where they challenge the circumstances during which the will was made, such as the person who prepared the will is interested in the estate. So certain clauses are made to his or her benefit. Or another situation is where when the will was made, there was no independent legal advice, or maybe where the witnesses are actually the beneficiaries to the will. Other circumstances are where they were challenged as to maybe when the will was made, the testator was under the undue influence, i.e. The person was coerced, was forced to execute the will. Or the most common one is forgery or fraud, meaning they challenge as to the authenticity of the signature, that the will was not actually made or signed by the person, by the testator. And when situations like this arise in court, they will usually require a handwriting expert to examine the signatures of the testator. So what happens if there's no will, or if the will is declared invalid? Then there will be no grant of probate, there will be no executors, the will be ineffective completely. Then what happens? Then persons interested to the estate, which are usually beneficiaries, will need to apply to the court for a grant of letter of administration in order to administer the estate. So here the court will look at who is the suitable person to appoint as the administrator. The court will appoint the most suitable person, so which will usually be beneficiaries. So when there's no will, there will be no clauses as to who gets what, who are the beneficiaries, what we are entitled to, what are the assets listed. All these will not be available written down in a document. So the manner of distribution will follow the Distribution Act, which I will share with you shortly. But before that, let's see who falls under persons interested. So persons interested are usually beneficiaries, like I said earlier, persons who are entitled to the estate, such as spouses, children, parents, siblings, great-grandparents, and so on. And the Distribution Act sets out the manner of distribution, the entitlements, and the percentages each person is entitled. I'll leave this table up for a short while for a brief perusal. So let's look at the first row. So if there's a spouse surviving the estate, no parents, no children, then the spouse will be entitled to the whole estate. If there are no children, but there are spouse and parents surviving the estate, then they'll be entitled to half each, and so on. I will now move on to the duties of executors or administrators in situations of grant of the letter of administration, and trustees. So I will touch on certain points, which are the eligibility, duties, powers, and remuneration granted to executors or administrators of the estate. So who are eligible to be executors or administrators? They have to be 18 years old and above, and there's only a maximum of 4 executors allowed to be appointed at one time to be acting jointly. And if one of the executor passes away, representation of the estate accrues to the surviving executors. So let's say 4 persons are appointed, as stated in the will, one passes away, then his or her duty will pass to the surviving executors. But sometimes their testators who are more careful, they will actually nominate persons who will take over any of the executors who predeceases or renounces their executorship. So we'll now look at the duties of executors or administrators. So what does an executor need to do, or what do the executors need to do when the testator passes away? Of course, number one, locate the will, and then go look for a lawyer, because you will need to apply for a grant of probate or the grant of administration, letter of administration, before you can administer the estate. Then you need to ascertain the assets and liabilities of the deceased of the estate. You will then have to, of course, go to the banks, go to the government agencies, credit card companies, and all these companies and agencies to inform that this person has passed away. And then Once the grant of probate, once the grant is issued by the court, you move on to administer the estate. Note that one important duty here is your duty as an executor is a fiduciary duty to the beneficiaries, which means everything you do as an executor and trustee of the estate is for the estate and for the beneficiaries, but not for yourself. You cannot benefit under the estate. So what does it mean by administer the estate? So here we have, look, you have to pay the estate's debts and liabilities. So any debts due, you have to pay all of the debts due, the funeral expenses, pay the secured creditors, unsecured creditors before you can distribute the assets in accordance with the will to the beneficiaries. So you collect, you ascertain, collect all the assets, movable, immovable, and then you lay out what are the debts and liabilities that the testator owes, pay them off, and then only you can distribute the assets in accordance with the will or the Distribution Act if there's no will. So after everything, if they are residuary assets, meaning assets which are not listed in the will, maybe the testator forgot, or if there are new assets which arise, such as interest, fixed deposit, or anything like that, it falls under residuary assets, and residuary assets will be distributed in accordance to how the testator wishes, as stated in the will. There will be a clause that states that all residuary assets will be distributed, are to be distributed in accordance to this percentage. Or if that is not stated in the will, it will follow the Distribution Act, the table which I showed you earlier. And what happens if there are assets outside of Malaysia? Then the executor will have to apply to reseal that grant of probate or the grant of LA in that specific country. So all executors and administrators owe a fiduciary duty to the beneficiaries. What does this mean? As executors and trustees, you're basically holding all the assets on trust for the beneficiaries. So you're required to act in good faith, you're required to act reasonably and impartially, and everything has to be in accordance with the law, has to be in accordance with the will. So if there's any breach of this duty, then interested persons, i.e. the beneficiaries, can take a legal action against you for breach of that duty. So at all times, you have to act in the best interests of the beneficiaries and estate. One more point to add is that the logic behind this is this. Everything under the estate belongs to the beneficiaries, technically speaking, right? So if you don't act according to what the will has stated, if you miss out a certain investment, if you cause loss to the estate, then the beneficiaries can say, look, you were negligent. Those assets are supposedly mine, but because of your negligence, because of your mistake, you caused loss, which then I have to suffer. So in that sense, this executor-beneficiary relationship is actually a fiduciary relationship. And so at all times, the executors and trustees hold the properties on trust on behalf of the beneficiaries. So before the assets are actually transferred to the beneficiaries, before those assets are fully administered, the assets, the executor or the administrator actually holding those assets on trust. And at all times, they're supposed to comply with the Trustees Act, and they have to prepare the accounts, they have to render all the accounts to state all the monies received and dispersed during administration. So when does the duty of an executor end? The duty of an executor or an administrator ends when the estate is fully administered, when you have rendered all proper accounts, monies received, monies dispersed, and you have obtained discharges from all beneficiaries to confirm that they have received their respective shares in the estate. The powers of executors and trustees are actually quite wide, as provided under the Probate Administration Act and also the Trustees Act. Basically, you have the power to dispose of properties, you have the power to enter into contracts, you have the power to invest, to buy insurance, power to transfer properties, and all of these powers, as long as these powers are exercised in the interest of the beneficiaries. So if, let's say, an asset such as a share is depreciating, so you can apply to the court to dispose of that share because it's causing loss to the estate. And a lot of people usually ask whether executors or administrators do get paid, because technically speaking, everything they're doing is for the estate, it's for the beneficiaries. So do they get paid? Yes, you can apply to the court for a certain sum of remuneration, but it's only up to 5% of the total value of assets collected. And at the end of the day, it's the discretion of the court whether to remunerate you, and if yes, how much. So it depends on the complexity of the administration, whether there are a lot of assets, whether it involves a lot of traveling, involves a lot of processes which takes a lot of time. It all depends on the work which is done, complexity, and the value of assets collected at the end of the day. So before I pass the floor to my colleague Prisilla, just to sum up on the differences between executors and administrators and trustees is this. So executor and administrator comes in when the testator passes away. And then what you do, you collect the assets, you pay off the debts, you pay off liabilities, and then you distribute the assets, right? So once you've done that, your duty as an executor or an administrator technically has ended, okay? But no, you're still an executor, it's just that your duty ends there. And then you will be holding the remaining properties on trust. Let's say if they're minors, you have to hold the properties until they are 21 or they are or 18, depending on what the will says. If the will doesn't say that, then it's 18. Or if there are any other assets which are forthcoming later in the future, those assets, you will hold them on trust until you distribute them to the intended beneficiaries. And the line between executors and administrators and trustees is actually it's actually quite thin and sometimes a bit blur. So it depends on the individual facts and circumstances of each case. I will now pass the floor to my colleague, Prisilla.
Thank you, Vivien. Hi everyone, I'm Prisilla. Thank you for joining us today on our MWKA online talk on duties of executors and trustees, what you need to know. My top points today are common breaches by executors and trustees, and also how beneficiaries can protect their interests. I'll now begin with my first top point, which is the common breaches by executors and trustees. The common breaches that we often see include breach of trust, where executors or trustees have been acting in their own self-interest, and they may have also been appropriating money. Another example of which is conflict of interest. For example, an executor buying the estate's property at a lower price for his or her own benefit, or where the executor or trustees fail or refuse to distribute assets or fail to provide you with any estate accounts. Moving on to the second top point, how beneficiaries can protect their interests. Number one, we highly recommend or highly encourage beneficiaries to have a discussion with the executor or trustee, together with all the stakeholders or beneficiary of the estate. During such a discussion, you should request for an update on all the estate's affairs. You can request the executor to provide you with an estate account. You can ask them about the distribution of assets status, or the dividends accrued from shares, or rental income generated from properties if the deceased have left any properties. If the dispute between you and the executor persists, you can commence an administration action against him or her at the High Court. The purpose of an administration action is to obtain directions on questions that arose during the administration of an estate. This procedure is provided under Order 80 of the Rules of Court 2012. The definition can be found under Order 80, Rule 1 of the Rules of Court 2012. It simply means an action for the administration under the direction of the court, of the estate, of a deceased person, or for the execution under the direction of the court of a trust. I've created this flowchart here. There are generally three categories of situations where you can commence an administration action against the executor. The first one being, in order to determine questions or issues that arose during the administration of an estate or in the execution of a trust. The second situation is, in the event that you want the court to determine the composition of any class of persons having a claim against the estate of such a person or in any property subject to a trust. The third category is you can ask the High Court to determine the rights or interests of a person claiming to be a creditor of the estate. The examples of questions that you can ask the High Court are such as whether accounts should be provided periodically, whether an act of selling a property should be done, whether an executor or trustee should be removed, whether additional trustees should be appointed in complex cases. The reliefs that you can seek from the High Court will include an order to verify accounts, an order to require payment into court, an order to direct a person to do something or abstain from doing something, an order to provide any sale or purchase or compromise or any transaction by a person in his capacity as executor, or an order directing any act to be done in administration of estate. Moving forward, if your executor or trustee has committed serious misconduct in administering the estate, you can apply to the High Court for the revocation of the grant of probate or grant of letters of administration issued under the Probate and Administration Act. This procedure is provided under Section 34 of the Probate Act, which reads as follows. Any probate or letters of administration may be revoked or amended for any sufficient cause. Interestingly, the phrase sufficient cause is not defined in the Probate and Administration Act. In the Federal Court case of Wee Koo Boon Gong, deceased, the Federal Court has determined that in order to remove an executor or administrator, this involved an objective test. This objective test will require the courts to determine the welfare and interests of the beneficiaries of an estate as paramount criterion. In the event that the Federal Court decides that it is in the welfare and interest of the beneficiary to remove the executor or trustee, then they will proceed to revoke the grant of probate or grant of letters of administrations provided. This approach was similarly followed in Damayanti Kantital, Doshi, and others in 1998. An example of situations where the High Court has revoked the grant of probate or grant of letters of administration are such as where there have been a serious misconduct committed by the executor, trustee, or administrator. This perhaps will involve administrators or executors misappropriating monies and have refused to acknowledge such misconduct. Therefore, if the beneficiary have no option, they can actually commence an action to remove them and take over the administration of an estate. Secondly, the court can also revoke the grant of probate or grant of letters of administration if the relationship between parties has deteriorated to the extent that it can no longer be effectively to administer the estate. Thirdly, is where the grant of probate or grant of letters of administration was obtained by misrep or fraud. I will now hand the floor over to Karmen for the Q&A session.
Thank you. Thanks, Prisilla. So thank you once again, Vivien and Prisilla, for sharing your insights with us. We will now take questions that some of you have posted on Slido. So remember, you can ask us questions on Slido either by scanning this QR code or going to Slido's webpage and key in the code 10850. So we will then move on to Slido. The first question is, what should the executor do if one of the witnesses to a will has died? I understand that probate application requires statutory declaration from two witnesses. So perhaps Prisilla can take this question.
Sure, thanks, Karmen. The question basically is asking whether what should executor do if one of the witnesses to the will has died. Actually, according to Order 71 of the Rules of Court, in the event that the court feels or thinks that there is doubt as to the validity of the will or validity as to the execution of the will, they can request the witnesses to affirm an affidavit. The rule generally requires one witness to affirm the affidavit. So in the event that you have two, that would be great. If one of the witnesses have passed away, it should be fine as well.
I see. All right. Thanks, Prisilla, for answering the question. Moving on, as an executor of a will, how do he or she covers his or her cost and time? Perhaps, Vivien, you can take this question.
Thanks, Karmen. As explained just now, you can apply for remuneration. That's for the work that you have done and the time that you have spent. And it's up to a maximum of 5% and at the court's discretion. Whereas for the costs that you have incurred, such as expenses or disbursements, you can actually claim that from the estate. You don't have to apply to the court, but you have to make sure that you have proper documentation and all the accounts are rendered properly, so that there will be no challenges to the way you manage your duty, to the way you exercise your duty later on by the beneficiaries, if any.
All right, thanks, Vivien, for the answer. Okay, let's move on to the next question. Is a will automatically revoked upon marriage? So perhaps Prisilla can take this question.
Thanks, Karmen. Yes, a will generally be automatically revoked upon marriage. Therefore, if you are not married, we will not suggest you to make a will anytime soon.
Okay. All right. So, okay, let me read off. Okay, moving on. The next question is, if a person dies intestate, are all actions to get the grant of letter of administration at court, or is there other place to get that order to appoint an administrator? Perhaps Vivien, you can take this question.
Thanks, Karmen. That's a good question, because apart from the court, there are actually two other places which can grant you the letter of administration. So it depends on the size of the estate. So if the gross estate consists of wholly or partly immovable property, for example, a house or a land which exceeds 2 million, then the administrator will have to apply to the court for the letter of administration at the High Court. Whereas if the estate is a small estate, then the person interested can go to the asset distribution unit of JKPTG or the land office to get the letters of administration, and it will be in the form of a distribution order. And by small estate, we mean to say a wholly or partly of immovable properties and not exceeding 2 million in total value at the time of the application for the grant of LA. Thirdly, if the gross value of the estate is only movable properties, i.e. cash, and is less than 600,000, then you may apply to Amanah Raya Berhad, that's ARB, so for the letter of administration, and similar as the one you get at the land office or JKPTG, it will be in the form of a declaration order.
See, all right, thanks, Vivien. That answers the question very well. Let us move on to the next question. If a house is given to two beneficiaries under the will in equal share with an outstanding housing loan, who will then decide to sell the house to pay the loan? Is it the executor or the beneficiary? Prisilla, we can take this question.
No problem. This question, in order to answer this question, we will need to look at the terms of the will. Firstly, we will need to determine whether under the will, the executor has a power to sell the house. In the event that the executor does not have a power to sell the house, therefore the beneficiaries will get to decide whether the house should be sold. Secondly, if there is an existing house loan, it will form part of the liabilities. So in the event that the estate has surplus in relation to assets, therefore these outstanding housing loans should be settled before distributing any assets to the beneficiaries. So it really depends on the terms of the will. You will first need to look at what powers did the testator grant the executor, and secondly, whether there are any surplus in relation to assets.
Okay, all right. Next question. What happens if the liabilities of the estate... Okay, hold on. Yeah, let me get... Okay. Sorry. Okay, so next question. What happens if the liabilities of the estate are greater than the assets? So, Prisilla, maybe you can take this question.
Sure, no problem. What happens if the liabilities of the estate are greater than assets? As a general rule, the executor or administrator is required to settle liabilities first before distributing any assets to the beneficiaries. given that in this question, liabilities of the estate are greater than assets, therefore the beneficiary will unfortunately not get anything under the estate.
All right, thanks Priscilla for your answer. Moving forward, do we need to get a valuer to ascertain the value of immovable property? Vivien, what are your thoughts on this?
Yeah, generally, we would advise you to get a valuer to ascertain the value of movable properties, such as houses or lands, so that there will be no disputes later on. Again, it's back to your duty of rendering the accounts improper.
Thanks, Vivien, for your answer. Okay, let's take the last two questions. Can a witness be part of the beneficiary? Any takers to answer this?
I can take that. A witness cannot be, a beneficiary cannot be a witness to a will. A beneficiary spouse also cannot be witnesses to a will. However, if you're an executor, you can witness the will.
All right, thanks Priscilla for answer. Okay, let's move on to our last question. If a person dies without a will, can the family still remain or stay in the existing property if it's under the name of the deceased pending the court process? Maybe one of you can take this question.
Yeah, I can take that question. Yes, generally you still can stay in the property because if you're a family, then most likely you'll be entitled to the estate according to the Distribution Act. So yes, you can still remain and stay in the property pending the court process and further determination among the beneficiaries later.
All right. So yeah, so that's the end of our Q&A session. Thanks to everyone for the question. There's one more. Let's take the last one. Okay, if a person gets married next year, should he write a new will after marriage?
I will answer that question.
Okay, thanks.
If a person gets married next year, should he write a will after the wedding? Yes, you can write a will after your wedding, and depending on your circumstances, of course, yes, my answer is you can write a will after your wedding. I've just now, I think one of our participants, Mr. Tan, raised his hand. Mr. Tan, are you there? Oh, Mr. Tan, are you there? Okay, I guess he is shy. Karmen, any other questions?
No, this will be the last question. So, yeah. Thank you everyone for your questions, and also thank you Priscilla and Vivien for answering all of our questions.
Thank you, Karmen.
So before we conclude, I have a few announcements to make. First, please join us again for our upcoming talks. On the 16th of December, our senior associates, Ms. Hannah Patrick and Ms. Denise Pang, will give a talk on breach of contract to COVID aftermath. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. Thirdly, please do follow or like our social media accounts. Fourthly, if you would like to speak with our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. The link is also posted in the chat. So I will leave this slide up for 10 seconds for everyone to take a screenshot or to take a picture. So thank you everyone once again, and we hope you have found today's session informative and useful. We hope to see you at our next talk. Stay safe, practice physical distancing, and have a nice day.